One courtroom, dozens of rent cases, real
Oh,
consequences.
And
in
get all
person.
those.
So,
Yes, ma'am.
oh, I'm sorry. It's an in person. So where do I go?
You go to the 14A1 District Court down by the Sheriff's Department off of Washington.
Okay.
Okay?
I'll be there August 29th at 12 noon.
Very good. Look forward to it. Thank you.
Thank you so much. I appreciate it.
Yes, ma'am. Court calls the case of
Okay.
Arbor
Bye-bye.
Meadows versus Milton Reyes.
Here, Dana Hall on behalf of Arbor Meadows.
I'm here.
All right. And good morning, Mr. Reyes. If you have a camera on, need your camera on. And what is plaintiff's claim?
Including costs, $2,384.31.
All right. And Mr. Reyes, how are you intending on getting that paid, sir?
The problem is not pay me my job.
Pardon?
The problem is my job not pay me now. Me pay my boss pay Monday, and I have money for the office.
All right. So on Monday, you'll have the money, you think?
Yeah, and half the one
Half
month.
of it. You'll have half of it on Monday.
Yes.
Okay. So about $1,200 or so?
Huh?
You'll have about $1,200 on Monday?
Monday afternoon or Tuesday the morning.
Okay. But you'll have about $1,200?
Yes, sir.
All right. And that's the 18th.
On Monday, yes.
18th, 19th, somewhere around there. Okay. All right. And then how are you going to get the rest of that paid? Do you know?
The 1 week more.
One more week. Gotcha. Okay. So let's do this. I'll
The
adjourn this to
Monday.
August. I'll adjourn this to August 29th, 2025 at 12 noon. If you pay the 1,200 by the 18th, 19th, and then you need another week, you may be able to get everything paid off before you come back.
Okay.
Okay?
Okay, sir.
All right. I set that date. That's an in-person hearing. If you get everything paid off, I don't need to see you, but if you don't, then I'll need to see you on that date.
Okay.
All right. Thank you.
You're welcome. Happy good day, sir.
Bye-bye. You do the same.
Bye.
Arbor Meadows versus Charles Carter and Julius Rutledge.
Dana Hall on behalf of Arbor Meadows.
They are not checked in. You did pay for second service. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Go ahead.
And Your Honor, this is a non-payment of rent case. At this time, the past due rent is $2,448.08. The costs are $214 for a total of $2,662.08.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Is that it for you, Ms. Hall? I think so.
No, I think I have Woodview Commons and Beale Properties.
Oh, you have Beal. Okay, gotcha. Beal Properties versus Morgan Tilley and Jarrett Sexton.
Dana Hall on behalf of Beale Properties.
Tilley, Sexton, not present. You may proceed.
Your Honor, this is a non-payment of rent case, and as of now, the past due rent is $1,693.70. The costs are $214 for a total of $1,907.70.
Judgment to the plaintiff, that's by default for possession. Redemption amount in the amount requested. Writ issue in 10 days. Woodview Commons versus Connie George.
Dana Hall on behalf of Woodview Commons.
Connie George, they are not present. You may proceed.
Thank you, Your Honor. At this time, the past due rent is $7,570. The costs are $175 for a total of $7,745.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Arbor Meadows versus Tara Downey, that matter is dismissed on plaintiff's motion without prejudice.
Okay, I think that's all I have.
That's
Thank you.
Okay, take care. Pine to Clover Lane versus Danelia Palacio.
Good morning, Judge. Jen Wilburn, P83143 for plaintiff. This one should have been a dismissal. If we haven't already sent it, I will get it in.
All right, very good. That case is dismissed without prejudice. Pine to Clover Lane versus David Alawali.
Jen Wilburn, P83143 for plaintiff. Your Honor, this one is also a dismissal.
Dismissed. Okay.
As will be 2860-2861.
Gotcha. Okay. I like the way we're rolling here. Hang on. All right, let me just call him at least because we still got him. Pines at Clover Lane versus Evan DeCossin. That matter is dismissed. Plaintiff's motion without prejudice. And also Pines at Clover Lane versus Jasmine Gilliard. That matter is dismissed on plaintiff's motion without prejudice. All right. Then I have Pines at Clover Lane versus, is it Rolando Eccleston?
Jen Wilburn, P83143 for plaintiff.
All right. There's your name, sir?
Rolando Eccleston.
Thank you, sir. All right. And what is plaintiff's claim in this case?
This is a non-payment of rent case, Your Honor. I show a balance $2,271.52 plus $175 in costs for a total of $2,446.52.
All right. And sir, how are
In
you?
eviction court, silence costs you everything.
Amount to pay the balance in full by Friday, next Friday. I believe it's the 20th.
The next Friday, the 22nd?
22nd, yes, sir. And I can make a payment. I can make a lump sum payment today if need be to satisfy anything.
All right. How much can you pay today?
I can pay at least $1,500.
Okay, fantastic. Okay, I'm going to put that you're going to pay $1,500 today. And then you're going to have the balance you think paid by the 22nd.
That's my next payday, sir. I will have the balance on that date. Yes, sir.
Got it. Okay. So what I'm going to do is I'll adjourn this then to August 29th, my next date, 2025 at 12 noon. If you get everything paid, they'll dismiss the case out, then you're all set. But make sure that everything's paid. Otherwise, we'll have to see you on that date in person.
Understood. Thank you very much.
All right. Thank you, sir.
Thank you, Judge.
it?
That's all I have.
Is that
Have a
it?
wonderful weekend.
You do the same.
Thank you.
Avalon Housing versus Ronald Wilson.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Ronald Wilson, they are not checked in. If you'd like to proceed, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
The rent to retain possession is $1,294, court costs of $132 for a total redemption of $1,426. Plaintiffs requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Is that it for you?
That's it. Have a wonderful weekend.
Wow. All right. Take care. Darlene Morin versus Emil Tito. Yay. And Emil Tito, I need you to unmute and turn on your camera, please.
My camera's broken right now, but you're just not working. Sorry about that.
Miss Morin?
Yes.
All right. What is your claim in this case? How much are you claiming is owed?
$1,750.
$1,750. Does that include your cost or no?
No.
Okay. All right. We'll work with that. All right. And Mil Tito, how are you intending on getting that paid?
I'm moving out like within the next day. As soon as I get my next paycheck, not this coming up Friday, but the next one, I'll pay probably $600 on that.
Okay, so you're gonna move out. When are you gonna move out of the premises?
It looks like tomorrow probably.
All right. So you're gonna be moving out on the what is that? The 16th?
Yeah, I think so. Yeah.
Okay. And then you're gonna pay to the plaintiff 600 by your next paycheck.
Yeah, whatever that next. I'd have to look at the calendar.
Friday.
I'm not good.
So like the 22nd?
It's the 15th. No, by the 29th, every 2 weeks.
By the 29th. Okay. Yeah. So what I will do is I'm going to suggest that you contact the plaintiff, see if you can arrange a payment plan. They're requesting that you vacate the premises or pay them the rent, but you're vacating the premises. But I'm going to suggest
be moving out.
So if you listen to me, if what I'm going to suggest you do is contact the plaintiff, try to arrange a payment plan for the back due balance because they're also requesting a money judgment.
Okay.
Okay. I will adjourn this out to August 29th, 2025 at 1 p.m. That's an in-person hearing. So both of you will need to be here if you work something out, or if it hasn't been paid, you'll need to be here so that we can take care of this matter. Okay.
Okay.
All right. Thank you.
All right. Yep. You have a great day.
Thank you. Have a wonderful weekend. Thank you so much.
You do the same.
Thank you.
Yeah. Robert Pritzel versus Jeremy Lewis. Mr. Lewis?
Yes.
Okay, here you are. But the plaintiff is not here. Did you try to work something out with your landlord, sir?
To my understanding, he didn't want to work nothing out. Basically, I had left this property on like the 6th or the 7th. I plan on paying him his money. Yeah, probably.
Well, let me ask you. Hold on a second. You've already vacated the property?
Yes.
Okay, so here's what I'm going to do. He's not here. This case, he's only asking for possession of the premises. So since he's not here, I'm going to indicate that plaintiff failed to appear. This case is dismissed.
Thank you.
You're welcome. Have a good weekend.
You too. He got his keys too, by the way, Your Honor.
Okay. All right. You're good. All right. Take care now, young man.
You too.
Every name called, another rent struggle.
And Your Honor entered another order, a bond on appeal, under which 2 additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed, and as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Thanks.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter complained against.
Why was it an it wasn't an injunctive bond?
It should have been because we applied plaintiff and it wasn't granted, but this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid for over $44,000 of expenses that we paid the property taxes, we paid the homeowners insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or ordered whatever bond, but where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the $20,000. So that we're all, whether we're not on the same, we can all be on the same page or not. That's what happened, and that's why the $20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the $5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the $20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here. It is not before the court.
I'm raising that today, according to ex parte emergency motion and file, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be ripe to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. I'm just not, it's not before me. But the only issue before me is the $20,000 as an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the